Hello everyone, this is your host Urvashi Jahan. Welcome to Courts Today by Livelaw, your one-step destination to all legal developments in the country. Let us start. Starting with an update from the Supreme Court, which today dismissed a petition filed under Article 32 of the Constitution by an American citizen seeking asylum in India. The petitioner, who claimed to have discovered an alternative to petroleum, feared persecution if he returned to the United States. The matter was placed before the bench of Justices Vikram Nath and Sandeep Mehta. The petitioner appeared in person before the court today. On the last occasion, though the court had not issued a notice, it had instructed the additional Solicitor General to get instructions from the Union government. Today, the bench was apprised that the petitioner's visa was set to expire on 9th December this year. However, at this point, the petitioner raised apprehensions that there are chances that he might get imprisoned or killed in case he leaves. When the bench asked if he was facing any prosecution, the answer came in negative. However, when the petitioner again raised apprehensions, the court made it clear that the US government would take care of him. Further, it told the petitioner that there are courts in the United States as well. Based on this, the court dismissed the petition. A writ petition has been filed in the Supreme Court challenging the National Testing Agency's decision to give grace marks to students in this year's NEET exam for undergraduate medical courses. The petitioner is a NEET applicant. He filed the petition under Article 32 of the Constitution, arguing that the NTA's decision to award compensatory marks to 1536 candidates due to loss of time is illegal and unfair. The petitioner claims that using the normalization formula to give grace marks is wrong because it is arbitrary and violates Article 14 and 21 of the Constitution. He argues that this formula should not be used for exams meant to test subject knowledge, as it assumes knowledge rather than measuring it. He further explains that normalization formula is flawed because if a candidate answers the question incorrectly, the formula does not apply. And if the candidate answers the question correctly, they have already received the appropriate marks. The petitioner believes that the normalization formula should only be applied to unanswered questions in proportion to the time lost, since each question has equal marks and requires equal time to answer. Additionally, it was highlighted that since the exam was conducted in an offline mode, there is no standard to accurately measure the loss of time. There have been no evaluations or reports disclosed by the authorities to justify the grant of grace marks in the event of alleged loss of time. On 9th June, another petition was filed in the Supreme Court to recall the NEET-UG 2024 result and conduct of fresh examination. Also on 8th June, the National Testing Agency and the Union Education Ministry announced the formation of a 4-member committee to review the results of over 1,500 candidates who were awarded grace marks to compensate for the loss of time suffered while appearing for this year's NEET undergraduate exam. The Supreme Court today refused to set aside the criminal charges against the Karnataka MLA Vijay Raj Shekharappa Kulkarni. MLA Kulkarni of the Congress party is accused of a murder conspiracy of a BJP worker that took place in 2016. Yogesh Gowda, a Zilla Panchayat member of the BJP from Hebali constituency, was murdered by an armed gang at his gym. The bench of Justices P.V. Sanjay Kumar and Augustine Masi today dismissed the SLP filed by MLA Kulkarni against the Karnataka High Court order, which upheld the charges framed by the special court against him and 20 others. The main contention of the petitioner, as represented by senior advocate Siddharth Dave, was that the MLA has been named only in the second charge sheet filed by the CBI and that the statement of the widow of the deceased does not disclose his name. But the court observed that factually the case was not a one fit for quashing. The court said that the minister also wrote a letter to the chief secretary requesting the transfer of the public prosecutor because she was conducting the trial independently without being influenced by him. When Mr. Dave insisted on withdrawing the petition, the bench took objection to it and expressed displeasure at the trend of cases being filed and withdrawn on unfavorable outcomes. And now let me tell you, the Supreme Court's first ever computer-based test for the annual Supreme Court Advocates on Record examination faced technical glitches today. The candidates who opted for the online mode could not complete the exam due to technical problems. The AoR exam for the subject Practice and Procedure was scheduled to be conducted today from 11 a.m. to 2 p.m. at Guru Har Gobind Institute of Management and Technology at Anand Vihar, Delhi. As per primary sources who were present at the exam center, the Supreme Court registry officials announced cancellation of the online mode of the exam. The candidates were informed that the committee of judges overseeing the examination would further notify them about the future course of action. A total of 173 candidates were appearing for the online mode. According to many candidates, the computer systems faced several technical hiccups, such as server being down and the system hanging. Therefore, the candidates could not upload the answers. The pen paper written mode of the exam was held separately. The Supreme Court registry is yet to officially respond to this issue. You are aware that the Delhi government has approached the Supreme Court regarding the water crisis in Delhi. Last week, the top court had directed Himachal Pradesh government to transfer 137 causecs of water to the Hathnigund barrage in Haryana and asked the Haryana government to facilitate the transfer of the surplus water received from HP to Delhi. Moreover, the court had directed the Upper Yamuna River Board to submit the status report regarding the measures undertaken by it for the onward supply of water released from the state of Himachal Pradesh to Delhi. Today, while submitting the status report on behalf of the state of Haryana, senior advocate Shyam Devan informed the court that the defect in the petition copy had not been removed by the petitioners' counsels. Noting this, the bench comprising Justices Prashant Kumar Mishra and Prasanna B. Virale adjourned the hearing. The vacation bench said that they would prefer to read the files first so that they do not get swayed by the media coverage of the case. The Delhi government's counsel assured that steps would be taken to make sure that the defects were removed. In another update, a court in Bengaluru has today remanded the suspended Janata Dal leader Prajwal Revanna to judicial custody till 24th June in connection with this sexual assault case. The additional city civil and sessions judge passed the order after the SIT, which is investigating the case, did not seek further custody of Prajwal for the investigation. The SIT had arrested Prajwal at the Bengaluru airport on his arrival from Germany last month. The court had on the next day remanded him to custody till 6th June, following which his custody was extended till today. You are already aware that before the Lok Sabha elections, videos went viral showing women being sexually assaulted allegedly by Prajwal. After casting his vote, he had moved out of India. After the Karnataka State Commission for Women chief wrote to the state government seeking action in the matter, a special investigation team was formed which is probing the case. And lastly, Bharatiya Janata Party leader Suvendu Adhikari has approached the Calcutta High Court flagging instances of alleged post-poll violence taking place in West Bengal in the wake of the Lok Sabha elections. He approached a division bench of Chief Justice T.S. Sivangnanam and Justice Hirannamay Bhattacharya, stating that being the leader of the opposition in West Bengal, he was greatly concerned about the instances of post-poll violence against party workers and was seeking orders of protection for them. It was stated that numerous instances of violence had erupted across the state and that members and workers of the ruling party were involved in violence against rival party workers. Another BJP member and advocate, Priyanka Tibrewal, also mentioned a similar plea, and the court has tagged both pleas for hearing on 12th June. Earlier, a vacation bench of the High Court had directed the West Bengal police to take up complaints of post-poll violence over email and publish the same in the public domain. The court had also called for an affidavit from the police regarding the same and also cautioned that in case these complaints were not investigated according to law, then appropriate orders would be passed. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share, and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.